Good day. Let's talk about laws governing lost and found property. Let's start from the learning objectives. After studying this chapter, you will be able to discuss the concept of lost and found property, learn about lost, mislaid, and abandoned property, focus on hotel defenses to liability claims, and explain the statutory limits on hotel liability. Introduction, choice of law or governing law. A choice of law or governing law provision is a contract allows the parties to agree that a particular state's law will be used to interpret the agreement even if they live in or the agreement is signed in a different state. For example, many big corporations choose Delaware law and their contracts choice of laws provisions because that state's laws often favor corporations and offer some predictability when it comes to disputes. So, ang choice of law or governing law are laws to be used in the agreement of parties. Let's say a corporation consists of shareholder from different countries like Philippines, Thailand, and India. So, they agree to use the law in the Philippines so that it will be implemented and be the content of their contract. Yun ang susundin nilang batas. Let's move on. A lost and found property is an office in a public building or area where people can go to retrieve lost articles that may have been found by others, frequently found at museums, at amusement parks, and schools. A lost and found will typically be a clearly marked box or room in a location near the main entrance. Some lost and found officers will try to contact the owners if the lost item if there are any personal identifiers available. Practically all will either sell, give, or throw away items after a certain period of time has passed to clear their storage. The common law distinguishes between lost property and mislaid property. Lost property is a personal property that was unintentionally left by its true owner. Mislaid property is a personal property that was intentionally set down by its owner and then forgotten. At common law, a person who found a lost personal property could keep it until and unless the original owner comes forward. This rule is applied to people who discovered lost property in public areas as well as to people who discovered lost property on their property. Mislaid property, on the other hand, generally goes to the owner of property where it was found. The basic theory behind this distinction is that owner mislaid property are more likely to remember where the property is. Allowing property owners to keep it makes it easier for the true owner to recover the property. So the main role of lost and found property is to help those people to see their lost items and help those finder to look for the owner of the item they found. While the difference between lost and mislaid property is that, for instance, I put my wallet in the table, then I went to the comfort room, then when I came back, it's gone. That was lost property. But if I put it in the table, then I left because I thought I put it in my bag, that was mislaid. While when we talk about who will keep the item, maliwanag na ang finder ang magkikip pag public place nakita ang lost property at pag naman halimbawa sa restaurant nakita, isosurrender ito sa owner ng restaurant. That same goes to mislaid property. If you found the item, ibibigay sa restaurant kasi pwedeng balikan ng owner yung item na yun doon. Now, let's talk about the concept of lost and found property. It is human to be careless at times. A hotel or guests are human. The number of variety of articles lost or mislaid by guests vary on the size of the hotel or motel. Whenever an article is lost and found within a hotel or motel premises, a question arises as to its ownership. The purpose of the following section is to acquaint the innkeeper with the legal principle applicable to lost property and to give him legal guidance for handling the lost property. Next, title to lost or misplaced property. Property is never lost until the owner parts with it unintentionally and does not at any time thereafter know where to find it. Mislaid property is that which the owner voluntarily and intentionally lays down in a place where he can find it again but which then he forgets. Abandoned property is that which the owner voluntarily discards with no intention of reclaiming. Since maliwanag naman na tayo sa mislaid property, dako na tayo sa abandoned property. For instance, I clear my wallet, then I saw my high school ID. Since di ko naman magagamit, itinapon ko. Kung halimbawa makikita yun ng ibang tao, they will think na importante yun sa akin. Pero sa akin as a owner, hindi na. So that ID will be considered as an abandoned property kasi tinapon ko na. Now, let's continue. The law requires that the title to article must be in someone and as particular matter. The finder, whether he is an employee or a stranger to a hotel, and the innkeeper on whose premises the property was found will each insist that he or she has title. except where a statute otherwise provides title to lost or mislaid property remains with the true owner, but the true owner may never become known. Thus, it is important to determine who is entitled to possession. The answer to this question may depend on the place where the property is found. That is whether in private room or public place within the hotel. As a rule, a guest room is considered to be a private rather than a public space, and then the innkeeper rather than the finder is entitled to possession of the articles found therein. On the other hand, lobbies, dining rooms, ballrooms, function rooms, halls, and the like, to which the public has access, have been held public places. The cases generally hold that the finder, the person who first discovers and takes possession, is entitled to article found in public places. Na-explain ko na to kanina, but to be specific, the innkeeper or the hotelier will be entitled to the property if it is found in private places, whether the employee or the guest found it. On the contrary, if the item was found in the public place, the finder is entitled with the item. Let's move on. Statutes and local ordinances governing lost and found property. Most states have enacted statutes or authorized municipalities to adopt local ordinances that requires finders to report found property and deposit the property in a designated public place, usually local police department. The New York statute abolishes distinction between lost and mislaid property, treats all such property as lost, and accepts only instruments, document of titles such as checks, notes, draft, warehouse receipts, stock certificates, bonds, and insurance policies, which need not be deposited with the police, which, if negotiable, may be transferred to others who acquire full ownership rights. From definition of property, if property exceeds $10 in value, it must be returned to the owner if known. If unknown, to the police department. Failure to return it or turn over to the police is misdemeanor. The police will issue a receipt for the property and are required to hold it for the prescribed period of time depending on the value of the property. If the property remains unclaimed after a period of time, the finder obtains both title and possession, even against the true owner. A finder who is an employee will relieve himself for a further responsibility by turning the property over the innkeeper. The finder is normally provided a reasonable grace period, 10 days under the New York City Ordinance, to locate the owner so that owner may reclaim the item before it is delivered to the police. To avoid possible adverse claims between employees and innkeepers, all employees should be required by terms of their employment contract to turn over to the innkeeper all property found within the hotel, no matter where found, and to waive any rights they might otherwise claim as a finder. Finder is guilty of larceny if, without taking reasonable steps to return such property to the owner, he intentionally exercised control over the property of another which he knows to be lost or mislaid or to have been delivered because of a mistake about the identity of the recipient or the nature of or amount of the property. The New York penal law defining larceny is representative of penal statutes in most states on this subject. The prudent innkeeper should acquaint himself with the legal mandates governing the disposition of lost or mislaid property, not only as a matter of goodwill, but to avoid the civil and criminal penalties that may otherwise invoke. The companion problem of how to dispose of unclaimed guest property has also been the subject of statutory regulation. Care must be exercised to determine whether such property is in fact abandoned property, since mistake may render such sale violate the property's rights of the guest. In every case, the property in question must be held for minimum period of time specified. Local council should be consulted to ascertain whether any additional holding period is required. So there are statutes and local ordinances governing lost and found property. As a finder, it is your responsibility to return the item to the owner or else you will face legal consequences. Pag halimbawa sa public place mo nakita, you can surrender to police department. While if you were an employee, the responsibility will be passed to your superior pag itinurn over mo yung property that you found. Then magkakaroon ng reasonable period of time na palugit para mahanap ng owner yung item. If natapos yung palugit na yun, kailangan may proper consultation kung kailangan pang mag-extend. If that period of time end, pwede mo nang i-dispose yung item in your facility. So, we need to consider legal advices on how we will handle lost and mislaid property to prevent legal consequences and violation of guest rights na ayaw naman nating lahat mangyari. Kung mangyari ito sa atin, sir, in real life, we have to be responsible enough. I-surrender natin sa lost and found facility, police station, or sa owner ng place where we found the item. Kasi alam naman natin lahat na mahirap mawala ng gamit, lalo na kung mga important documents yung nawala. Okay, that's enough. Let's move on. Governing laws. How do you choose the governing law for your contract? People often underestimate the importance of choosing which governing law should be applied to a contract. In fact, it is one of the most important clauses to consider, particularly if there is any international element to your transaction. The main purpose of choosing governing law is to identify and define the terms in which the contract will be interpreted in case disputes arises. This helps avoid future misunderstandings and parties get comfort in performance of the contract. Halimbawa, may company owned by Thailand, then it will make contract with a company in the Philippines. So there are two parties involved which have different laws and different legal approaches. So kailangan pumili ng gagamiting law sa contract to avoid confusion that leads to misunderstanding. So yun na yung magiging governing law ng contract. Contracts without clear governing laws clauses can be problematic for international transactions involving multiple jurisdictions. In order to choose which law should govern a contract, think about the following. Which jurisdiction is better for the contract? Jurisdiction just means where a dispute will be resolved. It is important to understand that choosing a jurisdiction and governing law are different things. Nonetheless, they usually coincide because the enforceability of the contract depends on the legal system that will enforce it. In order to decide which jurisdiction to take into account the speed of the process, how easy it is going through the judicial system, the possibility of enforcement, etc. Which jurisdiction is better for the contract? So, ang pagkakaintindi ko kasi dito, there are times that there are misunderstandings and arguments within the corporation. So, there are need for legal decisions and judgments. So, we need to choose a state law na gagawin natin governing law kung saan mabilis at madali yung process ng pagre-resolve ng problem. And at the same time, pwede enforce sa place where the contract is used. Next, which law should be used for the interpretation of the contract? Think about what the contract is used for. English law, for example, has a very good reputation in terms of international transaction because of the number of commercial law precedents, making it easier for the parties to understand and apply it. In addition, consider the following: where the parties are based, where is contract performed, who is affected by the contract, and where are they based. Which law should be used for the interpretation of the contract? So, maliwanag naman na itong English law. Madali nga naman siyang intindihin. Tapos, where are the parties based? Halimbawa ay Thailand and Philippines. Where is the contract be performed? Halimbawa na lang ay sa Philippines. Who is affected by the contract? Syempre, yung company in the Thailand and the Philippines. Next, are there any law that should be avoided? Yes, usually laws are legal systems where a judge takes more active role in considering the fairness of the contract for the parties. This can affect the judge's decision on whether or not the contract actually took place or where corruption is more likely to occur. It is also advisable to choose governing law that is not a huge disadvantage to one of the parties, which potentially create an imbalance between them. There are laws that should be avoided for fairness of the contract. Since the user of the contract is from different base, sometimes there are laws that favor the other and become a disadvantage to the other. So we need to eliminate that law so that the fairness of the contract is present for the two parties. Next, what happens if there is no express choice in the contract? As said before, choosing a governing law is often neglected by a parties of a contract. Since there are different approaches of law in countries, if one party chooses a jurisdiction beneficial to their claim, there are bias which can lead to legal costs and high uncertainty. Nangyari yun, walang katapusang misunderstandings and arguments ang mangyayari, then the contract will be neglected. It is essential in an international transactions to take time and evaluate which law is better for the contract and the purpose of it. You should seek legal advice from an experienced lawyer, including a clear governing law and jurisdiction clauses in your contract will prevent future misunderstanding about the interpretation of or performance of the contract. Take note to that if we will establish a contract, we must consider seeking for legal advice to avoid inequality of rights between parties and to avoid future misunderstanding. Huwag tayong magmarunong, especially when it comes to law, kasi di natin alam yung legal consequences once magkamali tayo. Kailangan malinaw both parties ang governing law sa contract to be used. That's all for my report. Thank you for listening and have a nice day.
Hello po. For my part sa aming report is the internal procedure for handling lost and found property. Every hotel or motel should have a proper system for handling lost and found property. First is all employees should be instructed to deliver articles found by them or turned into them by a patron to a designated responsible person or office promptly. So dito po, halimbawa ay sa hotel, lahat ng employees dapat alam kung saan ilalagay ang mga nakuhang items na hindi sa kanila or naiwan ni guest. Or if may guest na nakakuha ng gamit tas binigay sa isang employee, kailangan they know kung sino ang pagbibigyan or office ng mga nakuhang gamit. Dapat alam po ni employee. Si guest wala pong kailangan hanapin na specific person. Kung sino lang po yung nagtatrabaho po dun. Hindi na po obligasyon ni guest. Kasi halimbawa po, paano kung busy si guest, kailangan niya pa po hanapin si desk control supervisor. Pero, hindi naman po ganun yung dapat. Kahit sino na lang po sa hotel na employee, pwede niya po ibigay kasi sila po yung may alam kung kanino po ibibigay yung item. Next is a record should be made in a lost and found record book of the date, place where found, the description of the article, the name of the founder, and if found in a guest room, the name and the address of the last occupant, together with any appropriate remarks. So dito po, very self-explanatory na po kasi pag may nakikita nga daw pong tayong gamit, tayong mga hotel employee ay dapat ma-record lahat ng details nito sa isang lost and found record book. Tas halimbawa, ang mga laman po na dito ay date kung kailan mo nakuha, place kung saan mo nakuha. Tas description of the article, halimbawa po ay phone. Yung phone na po yun ay anong unit, halimbawa ay iPhone 6s. The color is silver. Tas name ng founder kung si guest po siya or kayo na hotel employee, and if found in a guest room, the name and the address of the last occupant para may idea na po at mas mabilis na pong mahanap yung kung sinong may-ari nung item. The article should be deposited in a safe place, presumably in the hotel safe, until claimed by the owner or until delivered to the police according to the law. So dito po, kapag may nakuhang gamit, kailangan na hindi inyo, may safe place po tayong pwedeng paglagyan. Sa hotel naman po, tinatawag itong hotel safe na nandun lang po muna na matatakal natin mamaya. Tapos hanggang makuha ng owner. Or pwede din daw po sa police natin ibigay. So last one is prompt efforts should be made to ascertain the owner. Dito po kailangan ng mabilisang effort para malaman ng ang owner tapos mabigay agad ang gamit para sa mas mabilis na serbisyo para may good impression din po ang ating hotel na mabilis po ang service natin. So, next is the hotel lost and found procedures. The goal of the lost and found is to ensure all items are returned to their rightful owner in a timely and efficient manner. When a guest check out from the hotel, unfortunately, if he had left something in the hotel rooms, the items has been deposited into lost and found section in housekeeping department. Dito po, pag may naiwang gamit si guest, nadadala po agad yun sa sa housekeeping department, sa lost and found section ni housekeeping department. First is after receiving of lost and found articles from the guest rooms, the desk control supervisor files all details in lost and found register. Dito po, desk control supervisor ang maglalagay lahat ng details ng nakuhang gamit na natakal po natin kanina na ilalagay sa lost and found record book. Tas ibibigay naman ng details ng hotel employee na nakakuha or guest. Pero yun nga po yung nasabi ko kanina, pag busy si guest, pwede po kahit sino employee sa hotel. Tapos si hotel employee naman po ang maghahanap kay desk control supervisor. Tapos, si guest, magbibigay lang po siya ng mga details kung saan po niya nakuha yung gamit kay hotel employee. Next is the desk control supervisor should prepare the lost and found form in triplicate. So, may tatlo po dapat na copy. May tatlo pong copy ihahanda si desk control supervisor. Where he should write the details of the article like date, time, location of the article found, description of the article, finder's name, receiver's name, signature, and room number. The article and the original copy of the form is stored in plastic bag and kept in lost and found cupboard. Next is, yung duplicate copy is sent to the front office to obtain the data of the guest. Kasi si front office po ang nakakahawak po ng data ng mga nag-check-in na guest sa ating hotel. So, the triplicate copy is retained in lost and found book. Yung pangatlong copy naman po ay nasa lost and found book naman po siya may iwan. The executive housekeeper obtains the forwarding address of the guest from the front office to have the information in the registration card. If the guest's name is not known, the housekeeping department has to wait for the guest claim. If any inquiry about the article, the control desk supervisor cross-check with the register. So, si control desk supervisor nga po mag-cross-check sa mga details ng pag may nag-claim na po. Thus, if desk control satisfied with the guest answer, the lost article has been issued to concerned guest and obtain the signature of the person collecting the articles. So, kapag nasatisfy na po si desk control about sa details po ng item na sinasagot ng nag-claim, i-release niya na po yung gamit sa nag-claim po, tapos hingi po siya ng pirma na nagpapatunay na nakuha na po yung gamit. If the articles has to be mailed to the forwarding address, the article should be sent under the register post with the charges made known to the guest and claims the amount on cash on delivery. Pag ang gusto naman po ni guest na yung item niya po ay ipa-deliver na lang sa kanila, hindi na siya pupunta sa hotel, si guest po ang magbabayad ng fee para sa pagde-deliver. Hindi po si hotel. If the guest does not claim the article in spite of reminders, the article is placed for a specific period of time as prescribed by the management. After that period, the article is gifted to the finder. Halimbawa po ay, kasi hindi ko naman alam kung mga ano po yung limit, hanggang ilang buwan nilang taon po yung limit kapag may naiwan pong gamit. Ang mangyayari po, pag matagal na pong hindi kinukuha, kahit may mga reminder po na may nakaiwan po ng iPhone 6s dito sa hotel na to, please claim ganito ganyan. Ang nangyayari po, mapupunta na po sa finder kung sino pong nakakuha ng item na yun, sa kanya na po yung gamit na yun. In such situation, the housekeeping will issue gate pass to the employee for the security and the article out of the hotel. Lost, mislaid, and abandoned property. Lost, mislaid, and abandoned property are categories of the common law of property which deals with personal property or chattel which has left the possession of its rightful without having directly entered the possession of another person. There is an old saying that possession is 9/10 of the law. Perhaps dating back centuries, this means that in most cases, the possessor of a piece of property is its rightful owner without evidence to the contrary. More colloquially, this may be called finders keepers. The general rule attaching to the three lost types of property may be summarized as: a finder of a property acquires no right in mislaid property against everyone except the true owner, and is entitled to keep abandoned property. Lost items, things that are lost, may also acquire a new owner through possession. Most states have statutory procedures in place for establishing ownership rights in lost property. So, tinatawag po siyang lost items if personal property is considered lost if the owner has involuntarily parted with it at di niya alam kung saan niya naiwan. Next is, matatawag siyang mislaid items naman po kapag pag sinadya ni owner na iwan ang isang item sa isang lugar. Tapos, may idea naman siya kung saan niya naman makikita. Pero, after some time, nakalimutan niya bigla kung saan niya naiwan. Pag abandonment naman po, mislaid or lost property may be deemed abandoned if a mislaid or lost property is abandoned. The finder may retain the items and claim ownership. Pag abandoned naman po, or may word na abandoned, means inaabandon na ni owner yung item. The owner has intentionally relinquished all rights. Mislaid or lost property may be deemed sa finder na po yung item na yon, kasi sinadya na po ni owner na maiwan po yung gamit na yun. Wala na siya po siyang planong kunin ulit yon. So, yun lang po sa aking report. Sana po may naintindihan po kayo. Thank you.
So 4.2.1 Lost property. Property is generally deemed to have been lost if it is found in a place where the true owner likely did not intend to set it down, and where it is not likely to be found by the true owner. At common law, the finder of a lost item could claim the right to possess the item against any person except the true owner or any previous possessors. The underlying policy goes to these distinctions are to hopefully see that the property is returned to its true original owner or the title owner. Most jurisdictions have now enacted statutes requiring that the finder of a lost property turn it to the proper authorities. If its true owner does not arrive to claim the property within a certain period of time, the property is returned to the finder as his owner, or is disposed of. In Britain, many public businesses have this dedicated lost property office, which in the United States would be able to call lost and found. Many exceptions may be applied at common law to the rule that first finder of the lost property has a superior claim of the rights over any other person except previous owner. So, for example, a trespasser claims the lost property which he finds trespassing in general inferior to claim of the respective landowner. As a corollary to these exceptions, a landowner has superior claim over the find made within the non-public areas of his property. So, if it's a customer's find a lost property in the public area of a store, the customer has the superior claim to the lost property over the store owner. But if the customer finds the lost property in the non-public area of the store, such as an area marked employees only, the store owner will have the superior claim as the customer was trespassing with his found it. So, dito naman, makikita natin na may superior claim daw kapag nakita ng isang finder yung lost property sa public area. Pero once na nakita ng finder ito sa area marked employees only, ang may superior claim daw doon ay yung store owner. So next would be the status of finders as employees or tenants of the landowners complicates matters because employees and tenants have legitimate access to non-public areas of the landowner's property that others would not without trespassing. Employees and tenants, however, still usually lost superior claim over lost property to their employers or landlords if the property is found within the scope of their employments or outside the actual base area respectively. So, paano naman daw kapag ang finder natin is employees or tenants? So, regarding with that, tinitingnan dun yung scope of their employment. So, kapag hindi yun sakop ng trabaho mo, hindi ka pa rin yung superior claim. Ang magiging superior claim pa rin dun ay yung landlords. So, another example is if the lost property is found by a tenant inside walls of his leasehold or by an employee embedded within soil of an estate owned by his employer, the landowner, as employer or landlord of the property where it was found, usually has a superior claim of the right over that of the finder. However, this is not always the case as long-term tenant who finds lost property within the leased area of his leasehold may have a superior claim over that or his landlord, especially if the landlord has never been to the property, while employers usually have superior claim over lost property found by their employees. Exception to this exists as well. A modern law sometimes grant an employee superior claim if turning over the lost property to his employer is not part of his job description, such as the employee is an interior decorator. Next would be the property law. Property law principles, policies, and rules by which disputes over property are to be resolved and by which property transactions may be structured. What distinguishes property law from other kinds of law is that property law deals with the relationship between and among members of the society with respect to things. The things may be tangible, such as land, or a factory, or a diamond ring, or they may be intangible, such as stocks and bonds, or a bank account. Property law then deals with the allocations, use, and transfer of the wealth and the objects of wealth. As such, it reflects the economy of the society in which it is found, since it deals with the control and transfer of wealth between spouse and across generations. Property law also reflects the family structures of the society in which it is found. Finally, became, it deals with such fundamental issues as the economy and the structures of the family. Property law also reflects the politics of the society in which it is found. Now is the property law and the Western concept of a private property. The sum of rights, privilege, power, and the legal persons could have in things called dominium, ownership, or less frequently proprietas, too frequently enough for it to be clear that the two words were synonyms at legal terms. The classical Roman jurists did not say that their system tended to ascribe proprietas to the current possessors of the things, but that it did is clear enough. A number of Roman legal rules denied the labor possessions to the person who was in fact true not legally in possessions in order to keep legal possessions in the proprietas. Further, the person legally in possessions was presumed to be the proprietas. This is clear enough from the procedures rules that required a person who was not peaceable to possessions of a establish affirmative that his title to the object was better than that of the peaceable possessor. Once the Roman system has identified the properties, it intended to prevent him from conveying anything less than all the rights, privileges, and powers that he had in the things. Thus, full use right divorce from the ownerships and usufructus could given only to the living person, at that persons could not convey those rights to another. The ability of an owner to agree to legally binding restrictions on his privilege of use, servitudes, sharply limited. Moreover, anyone who found himself owning of this jointly with other could require that the thing be divided into distinct ownership units. Now is property law and the theory of the early modern period. Beginning in the 17th century, development in property law both in England and on the continent can be related development in speculative jurisprudence. Generally, speculations about the nature of property is at least as old as Plato and Aristotle. Although property is considered sometimes quite critically in the writing of the church father of the Latin West and the medieval theologians, this writing had relatively little direct effect of the secular law. Next would be the classical theories of property. In the early 17th century of the Dutch speculative jurist Hugo Grotius announced that the theory eminence domain condemnations of private property. On the one hand, according to Grotius, the state did have the power to expropriate private property. On the other hand, for such a taking to be lawful, it had to be for a public purpose and had to be accompanied by the payment of just compensations to the individual whose property was taken. The idea was not original, but Lucius stated it in such a way that it became a commonplace of Western political thought. In the late 7th century, the German jurist Samuel von Frondendorf refined a theory of the origins of property rights that had been in existence since ancient times. Property, Frondendorf said, is founded in a physical power manifested in seizing the object of the property, occupations. In order, however, to convert the part of physical power into a right, the sanctions of the state is necessary. But the state cannot, Pufendorf seems to suggest, make a property right where physical possession is not present. Thus, both occupations and state sanctions are necessary conditions for the legitimacy of property. So now is 4.2.2 mislaid property. Mislaid properties refers to a property that has been left intentionally in a certain place or later forgotten. When a property is left in a certain place by the owner with an intention to take it later, and if the owner finds it difficult to locate the property later, then such property is called mislaid property. So, gaya nga ng sabi natin kanina, sa lost property, unintentional, sa mislaid naman is intentional. So, for the example, a wallet found in a shop lying on the counter near a cash register will be regarded as a misplaced rather than lost. So, under the common law principles, the finder of a misplaced object has a duty to turn it over to the owner of the premises. This based on the theory that the true owner is likely to return to that location to search for his or her misplaced item. However, if the true owner does not return within a reasonable time, the property becomes that of the owners of the premises. Mislaid property is different from the lost property. So, property is generally deemed to have been mislaid or misplaced if it is found in a place where the true owner likely did intend to set it, but then simply forgotten to pick it up again.
Hospitality law. Hospitality law has evolved especially within the legal profession in the last several decades. A typical hospitality law course covers the history of hospitality law, the impact of federal and state civil rights laws on the hospitality industry, and an extensive discussion of contract law, including discussion of remedies for overbooking and a guest breach of the contract regarding a reservation. In hospitality law are all about on how hospitality law evolved. By generation or by decades, even in federal laws and state civil rights on hospitality industry, patungkol sa mga bookings, reservation, overbooking, etc. Kasi ang pagbubook or pag-login or pag-log out ay napakadali na lang sa ngayon because of the internet. Contracts and reservation. Historically, most hotel arrangements were booked through travel agent. All through internet bookings today are still primarily through travel agents. Many are made directly with the hotel properties through websites and offer general travel arrangements, or in some instances, specifically hotel arrangements. Several years ago in Florida, hotels were imposing an energy tax which was only disclosed by a small sign in the hotel room, adding in some instances $15 per day to room charge. The written confirmation of a guest reservation received either by email or snail mail generally will include the dates or stay the rates, and perhaps a category for the accommodation such as garden view, ocean view, or junior suite. If the areas in which the properties are located are significantly different, security issues also arise, particularly if there is less security at the lower rate property of which the area is not deemed as safe. Because of the economic climate, many properties have altered their mating contracts to require non-refundable deposit after a certain date, with or without attrition clauses. Karamihan sa mga hotels ay nagbubook using travel agent. Sa ngayon, sa internet na lang o website napunta para mag-book. About the guest reservation, they email you or snail mail pag magpapa-reserve or nagpa-reserve, and they include the date and time of your reservation. Also, you can choose in a garden view, ocean view, or even junior suite. If dumating ka sa date and time ng reservation mo and pag yung hotel is puno na, may tinatawag ang hotel na walk. Yun ay pag nakapag-reserve ka na and nawalan ka na ng rooms or slot dun sa hotel. The hotel can accommodate and magbibigay sa'yo ng rooms ng hotels, even your expenses na babayaran sa hotel na naka-charge. Generally, there will be a master billing for a group activities, and each individual will be responsible for his or her own hotel rooms and miscellaneous charges. The group also contract for audiovisual service, golf and tennis tournaments, sightseeing, and several meals, all of which were cancelled where the group could not attract enough of each member to attend the meeting owing to the served economy.
APRADA Chapter 4 Laws Governing Lost and Found Property Part 7 Risk Management. Risk management has become a preeminent concern for any hotel, large or small, because of the unique issues that arises in the field of hospitality law. Typical problems involving risk management are slip and fall cases or crime against guests, including assault and rape, break-ins and theft from the room, discriminatory issue involving both employees and guests, and issues of payment and bailments. Transfer of possession of goods or personal property from a person in possessions of the property to another with the understanding that the property will be returned. So, ang risk management is how a certain establishment, especially hotels, deals with management issues, maaaring sa mga guests ng hotels, employees, or sa mga rooms. Hotels and management companies of all sizes have ongoing and continuous training for their employees with regard to risk management issues and have established written guidelines and procedure addressing almost any circumstances involving risk management. The major hotel chains and management companies have law firms, generally multi-state or international firms, on retainer to provide risk management assistance and guidance as needed on an ongoing case-by-case basis. In a warm weather destination, particularly beach properties, numerous risk management issues arise with regard to the use of the beach by guests, including whether lifeguards will be on duty, whether they are employees of the hotels, a private service, or the city or country. Some hotels offer lifeguards at their swimming pools, others use private lifeguard services, and many hotels advise guests to swim at their own risk because there is no lifeguard on duty. Example, sa mga beaches, pag summer, maraming nagsiswimming or outing. Sa mga ganitong sitwasyon, may mga risk na pwedeng mag-arise like sa mga water sports. Para ma-manage ang mga risk na pwedeng mangyari, meron silang mga lifeguards. Other hotel-related liability issues involve until or inadequate lighting in emergency stairways, elevators that are unsafe or not maintained, both indoor and outdoor lights that are out, and rodent problems. Again, the hotel must take security measures to address this type of risk, which clearly are foreseeable in most circumstances. There are also numerous companies that specialize in security for hotel and related properties. with services ranging from a part-time private security guard to a full-time staff of security employees. The latter is more common than former, but the level of service depends on the size of the property. Sa mga hotels naman ay yung tulad ng mga stairs or hagdanan sa elevators, kung okay ba yung facilities nila. Kasama rin sa risk management kung paano dapat ang certain establishment mag-provide ng services at mag-care sa kanilang mga guests, pati na rin sa mga staff and employees nila. They need to secure the safety of all. Next is statutory limits on hotels' liability. Hotel guests should be aware of certain laws and regulations or policies that could impact their visits. Special concern affect the hospitality industry because its establishment hold their property open it to public at large. Generally, most day-to-day liability issues affecting hotels are based on early English common law theories of contract and tort negligence. Is duty to receive guests. The very first and most important public duty of the hotel is the duty to receive guests. But the duty is not absolute and it's subject to lawful excuses. Hotels may generally deny accommodation to a prospective guest for the following reason. If the person is unwilling or unable to pay for a room or other establishment privileges. Second, if the person is visibly under the influence of alcohol or other drugs or creating a public nuisance. If the person's use of a room or accommodation would violate the facility's maximum capacity. If the innkeeper reasonably believes the person will use the room or facility for an unlawful purpose. Last, if the innkeeper reasonably believes that person will bring in something that would create an unreasonable danger or risk to others. Generally speaking, to avoid liability for refusal to receive a prospective guest, hotel must reasonably believe a person is unable or unwilling to pay, plans to use the room or premises for unlawful purpose, or plans to bring a potential dangerous object onto the premises.
Liability for damage or loss to guest property. Public policy requires an innkeeper to be insurer of the property of his or her guest. An illegal act of the guest during the loss of or injury to his or her property shall not relieve the innkeeper of liability when the conduct is not the proximate cause of the loss. However, a person going to a hotel for an unlawful purpose shall not become a guest and therefore not entitled to a protection. The innkeeper shall be liable for the loss of the guest's property, and it shall extend to money, automobile, or contents of the automobile, and any goods carried for commercial purpose. The liability of an innkeeper for the loss or injury to another property depends on the existence of the relationship of innkeeper and guest between the parties at the time of such loss or injury. The liability or responsibility of the innkeeper starts at the moment of the delivery of the goods. An innkeeper is not liable even as a bailee for the property of persons who do not intend to be guests. Note that many hotels post a policy describing their limitations of liability for property and providing an in-room safe or a safe at the front desk for valuables. A stipulation in the form of a notice that the innkeeper is relieved of all responsibility for loss, or that the goods are kept at the owner's risk, does not relieve the innkeeper from liability for loss caused by his or her own negligence or that of an employee. In almost jurisdiction, the statutes modify or limit the strict common law liability of the innkeeper for the loss of or damage to property of guests. So, sinasabi po dito sa liability for damage or loss to guest property, kung ano man daw po yung kagamitan ng mga guests mula sa sasakyan at mga personal na gamit nito hanggat nasa loob na establishment ng hotel, ay responsibilidad na ito ng mga innkeeper mula pa lang po dun sa arrival. Kung ano man po yung laman nung sasakyan, yung automobile, kung ano yung mga personal na gamit ng guest, responsibilidad po yun ng mga innkeeper. Liable ang innkeeper kung sakaling may mawala or nag-cause ng damage sa property ng guest. But the liability depends kung ano ang relationship ng innkeeper sa guest nung mga panahong nawala yung gamit or nagka-damage yung gamit ni guest. But the innkeeper is not liable kung ang may-ari ng property na nawala or nagka-damage ay hindi naman guest ng hotel. Wala pang responsibilidad ang innkeeper kung yung taong nawalan ng gamit or nagka-damage or na ang kagamitan nila, hindi po liable doon ng innkeeper kasi hindi pa ho sila guest ng hotel. Kahit na may notice ang innkeeper, na-relieve sila kung may mawala man sa property ni guest. Pero kung sa kamay naman nila yung nawala or kasalanan nila kung bakit nawala or nagka-damage, liable pa rin sila doon, responsibilidad pa rin nila yung nawala or nasira. So, sa lahat naman po ng liability ni innkeeper, meron namang common law na nagtatalaga at naglilimita ng mga responsibilidad ng innkeeper sa naiwala at damage na nagawa nito sa gamit ni guest. Guest reservations. Most hotels have well-established policies for making, confirming, and holding reservation placed by prospective guests. A confirmed reservation generally constitutes a binding agreement, in essence of a reservation contract, between the hotel and the prospective guest. If the guest fail to use the reservation, the hotel is generally entitled to damages. On the other hand, if the hotel breaches a reservation contract, the guest can sue the hotel for damages. If the hotel actually has accommodations available but fails to supply them, as agreed, it may be liable for breach of its duties as an innkeeper. Dito na po sa guest reservation, pag po yung mga prospective guests nagpa-reserve, na parang na-confirm po ito sa pamamagitan ng reservation contract. Kung yung guest po ay nag-fail na ma-avail yung kanilang reservation or hindi sila tumuloy dun sa hotel kahit nagpa-reserve na sila, ang entitled po sa damage dun ay yung hotel kasi po parang nawalan sila ng room sale. Pero kung yung hotel naman po ang hindi nakasunod dun sa reservation contract nila na hindi na pwede po ang kinalagyan nito ay nagpa-reserve po si guest, inaccept po ni hotel, nagkaroon ng reservation contract. Tapos yung po pala ay fully booked na si hotel. So magkakaroon po sila doon ng responsibilidad kay guest. Kasi parang yung guest po ay mawawalan na ng matutuluyan na hotel, kailangan man nila maghanap. Pwede pong maghabol ng liability si guest sa hotel. Rights to evict persons admitted as guests. Hotel may generally evict a guest and keep the room rental payment despite the eviction for the following reasons: disorderly conduct, non-payment, using the premises for an unlawful purpose or act, bringing property onto the premises that may be dangerous to others, failing to register as a guest, using false pretenses to obtain accommodations, being a minor unaccompanied by an adult registered guest, violating federal, state, or local hotel law or regulations, violating a conspicuously posted hotel or motel rules, failing to vacate a room at the agreed check-out time. So, madali naman po itong intindihin. Yung rights to evict persons admitted as guests, pwede po patalsikin or paalisin po ng hotel yung mga guest na nakapagbayad na. Pero kahit po pwede po nilang paalisin yung guest kahit nang hindi binabalik yung bayad ni guest. Ito po ang disorderly conduct. Halimbawa po yung guest ay wala sa kaayusan yung kilos or pag-uugali. Yung non-payment, hindi po nakapagbayad. Yung bringing property onto the premises that may be dangerous to others. Halimbawa po, nagdala po si guest ng kutsilyo na ayaw niya, na pinasok niya dun sa establishment, which is bawal po. Or nagpasok siya ng alak or kung ano man pong metal na maaari pong makapahamak na iba. Tapos yung pong mga guests na hindi nakapag-register, yung pong mga guests na para false pretenses, yung pong hindi po tama yung information na binigay nila sa hotel para lang pong makapasok dun sa hotel. Tapos po yung mga minor ages po na walang kasama adult, hindi din po dapat yung pinapapasok ng hotel. So pag nalaman po nila na minor, pinapalabas din po nila. Tapos po yung mga nag-violate ng hotel law, tsaka yung pong hindi nakakaalis kaagad ng hotel dun sa agreed time na dapat mag-check out na sila. Generally speaking, to avoid liability for evicting a guest, the guest must have refused to pay, or the innkeeper must reasonably believe that the person used the room or premises for an unlawful purpose or brought up potentially dangerous objects onto the premises. Duty to persons who are not guests. A person who is not guest or intending immediately to become a guest generally has no right to enter or remain on the premises over the objection of the hotel, nor can a non-guest resort to public areas of the premises such as lobbies or the hallways without the consent of the hotel, despite the fact that the hotel has held itself out to the public with an invitation to enter and seek out accommodations remains on the premises only by the consent of the hotel. A widely acknowledged exception to this general rule is that a non-guest or stranger coming to the hotel at the request or invitation of an existing guest has a right to enter the premises for that purpose. Otherwise, the guest whom would unfairly be deprived of a privilege necessary for his or her comfort while at the hotel. However, the hotel may revoke such permission if the non-guest engage in conduct which would justify his or her eviction. Yung alam naman po natin na ang hotel po ay open para sa public para makahanap ng guest. Pero yung pong mga non-guest na nag-i-stay, parang ginawa lang pong tambayan yung lobby, yung pong hallway ng hotel, which is parang hindi naman wala naman silang balak na mag-check-in, nandun lang sila. Karapatan po ng hotel na palabasin sila dun sa premises ng hotel. Pero yung pong mga hindi guest talaga dun sa hotel na in-invite nung registered guest ng hotel, pwede po nila yung papasukin bilang bisita po nung guest sa hotel. Pero kung yung pong mga bisita po ng guest sa hotel ay may hindi po maganda yung ginagawa, wala po silang proper conduct or nakakaabala na po sila para po hindi po tama yung mga kinikilos nila, pwede po silang paalisin ng hotel kahit na po bisita sila nung guest. Duty to provide safe premises. The duty of a hotel to provide safe premises is based on the common law duty owed to business and social invitees of an establishment. Under common law, hotels must exercise reasonable care for the safety of their guests. Hotels have an affirmative duty to inspect and seek out hazards that may not be readily apparent, seen, or appreciated by patrons and guests. So, sinasabi po dito na responsible po ang hotel na mag-inspect dun sa kanilang mga premises, establishments, kung ano man po yung mga sakaling hazardous para po yung mga hazardous po or hazard na hindi agad nakikita, hindi madaling mapansin para po maayos nila kaagad or mabalaan yung guest or yung mga employees na rin po para makaiwas po sa disgrasya. However, the law does not protect hotel guests from their own negligence. An open and obvious hazard such as bathroom tile floor that becomes slippery when wet after reasonable use is not a basis for liability. So, yung example po, sinasabi po dito na hindi na responsible si guest kung sakali man pong may mangyari sa guest na yung pong obvious naman na hazardous, yung pagkakamali na po ng guest kaya sila na disgrasya. Halimbawa po yung sa bathroom tile, posible pong pagliligo nung guest, naging madulas po yung tile kasi po puro sabon, parang hindi po nabanlawan ng maigi yung tile, nadulas po si guest, hindi na po yung kasalanan ng hotel. Tsaka po, yung pong halimbawa po ang sa hotel, sa pool ng hotel. Dati po, yung sinasabi po dito, dati tinanggal na po yung diving board ng ng pool kasi po madalas pong may madisgrasya. So para na rin po makaiwas. So kadalasan din daw po na yung mga pool ng hotel ay walang nagbabantay or walang lifeguard. Pero may mga signs na nakalagay na halimbawa po ay don't run beside the pool or no lifeguard around. Para po yung ganun pong signs, dapat po responsive doon si hotel. Pero kung yung mga signs naman po doon na merong do's and don'ts na hindi naman po nagagawa ni guest, tapos sila po yung guest pa ang napahamak, hindi na po yung kasalanan ni hotel kasi meron naman po silang mga signs na maaaring makadisgrasya.
Harm or damage caused by other guests. Hotels have an affirmative duty to exercise reasonable care for the safety and security of their patrons. Sometimes, guests can also be a threat to other patrons and hotel staffs and properties. This happens most of the time when the person is under the influence of alcohol or intoxicated. This obligation may include the duty to evict or otherwise restrain drunken or disorderly guests or patrons who may possibly cause harm to other guests or their property. However, the hotel has also a duty not to cause foreseeable injury or harm the drunken guests as a result of eviction. Under those circumstances, hotels must seek more reasonable alternatives such as contacting the police and arranging safe transport of the drunken guests or escorting the person back to his or her room, if this can be done safely without the risk of recurring problems. Liability exposure is in the serving of alcohol to guests and non-guests. If the hotel actually creates the risk of harm by serving alcohol to an already intoxicated person, other laws come into play, most notably State Dram Shop Acts. So, ang sinasabi lang dito, the hotel should not serve any more alcohol to an already intoxicated person because if that person causes a harm, damage, or injury to other person, that person can sue or pwede nilang kasuhan yung alcohol provider. In that case, the hotel. Hotels can also lose their liquor licenses for serving minors in many states, can be sued for subsequent drunken driving caused by the minor. Hotels also may be liable for the personal injury of guests caused by the criminal act of another patron or guest, if it can be established that the hotel was negligent or at fault. Harm or damage caused by third persons. It's already understood that the safety and security of the guests is an affirmative duty of the hotel. Therefore, they must protect their guests and employees from foreseeable criminal acts of third parties. In most states, a greater burden of protection is placed upon hotels than upon landlords and other business owners. However, the law in this area varies greatly from state to state. Most states hold that hotels are not liable for third-party crimes unless at fault or there's negligence in reasonably protecting guests from foreseeable harm. For example, numerous court decisions nationwide have found hotels liable for failing to provide adequate locks on doors and windows. While the lodging industry does not recognize an official security measures that indicate compliance with standard practices and have in fact been used to establish legal precedent. This would include deadbolt locks, viewing devices or peepholes on room doors, chain locks, communication devices like telephones, enable emergency calls for assistance, and track bars for sliding glass doors. Closed-circuit television has been found to be fundamental to reasonable security and facilities with several entrances, high-risk parking lots, or remote locations.